बताइए
This is
138
appeal against the acquittal of the accused, my lord, that is the respondent. When, my lord, a check of rupees 2,60,000 was given by the respondent, my lords, on 13/5/2004, and wherein, my lords, a total of 17 checks were given to the present appellant, my lords. And, my lords, upon surrendering those checks to before the bank, my lord, they all were dishonored. Subsequently, my lords, the learned trial court, a notice was served. He did not reply to the said notice under section 138, and subsequently a complaint was preferred before the learned JMFC. And well, my lords, all the checks were exhibited before the learned trial court, and the learned trial court was kind enough to notice that the statutory presumption under section 138 stands satisfied, my lords. But since the respondent had also submitted a report of handwriting expert saying that I had given the check by filling my signature, but the date was written by the complainant, my lords. And on this basis, my lords, if my lords may kindly see page 23, that is para 18 of the learned trial court judgment, my lords. चेक में अंकित तिथि परिवादी के हस्तलेख में होने के अलावा नहीं होने के संबंध में प्रकरण का सूक्ष्मता से अवलोकन किया गया। प्रकरण में प्रस्तुत दस्तावेज प्रदेश P से P28 पर परिवादी ने अनादरण उपरांत चेक को वापस प्राप्त करने के संबंध में हस्ताक्षर कर तिथि अंकित की है एवं आदेश पत्रिका में परिवाद प्रस्तुति दिनांक 11/6/4 तथा तदुपरांत समय समय पर विभिन्न पेशी तारीख में उपस्थिति बाबत परिवादी ने के द्वारा किए गए हस्ताक्षर के साथ लिखी गई तिथि से परिवादी के हस्तलेख का मिलान करने पर चेक पर अंकित तिथि के हस्तलेख समानताएं प्रकट होती है, जबकि हस्तलिपि विशेषज्ञ को दिए गए नमूना में भिन्नता दर्शाता है। इस प्रकार यह दर्शित होता है कि परिवादी के स्वाभाविक हस्तलेख से भिन्न नमूना देने का जानबूझकर प्रयास किया गया। एंड मतलब ऑन दिस
हस्तलेख कंप्लेनेंट की जांच करवाई है,
मतलब कंप्लेनेंट की जो ऑर्डर शीट्स में जो नेचुरली साइन करते थे ये अपने ट्रायल में जो अटेंड करते हुए और जो स्पेसिमेन सिग्नेचर दिए गए थे, इनका ये कहना है कोर्ट का कि दोनों में भिन्नता है और आपने पर्पसफुली ऑर्डर शीट जो एग्जिबिट जो स्पेसिमेन सिग्नेचर दिए थे उसमें आपने जानबूझ के गलत साइन किए या दूसरे साइन किए जिससे ये भिन्नता प्रकट हो। तो मतलब अगर मान भी लिया जाए कि अगर ऑर्डर शीट में जो साइन है दैट इज नेचुरल और जो हमने स्पेसिमेन दिया दैट इज कॉन्कॉक्टेड और एन अटेम्प्ट हैज बीन मेड बाय मी टू डिफ्रॉड द हैंडराइटिंग एक्सपर्ट, then how can that specimen signature be computed or matched by the signature or date given on the check? There are three handwritings. One is on the check, date, the order sheet of the learned trial court, and the specimen signature before the handwriting expert. Court says that order sheet is correct. You have given a different signature on the specimen signature, but the same specimen signature is being relied upon by the handwriting expert to say that the letter or the number written on the check is of the same person. In this slide, I am relying on a case law. It is AR Online 2022 SC 1365, wherein the Honorable Supreme Court has laid down that if I may rely upon para 17, For such a determination, the fact that the details in the check have been filled up not by the drawer but by some other person would be immaterial. The presumption which arises on the signing of the check cannot be rebutted merely by the report of a handwriting expert, even if the details in the check have not been filled by the drawer but by another person. This is not relevant to defense whether check was issued towards payment of debt or in discharge of liability. My lords, he has not taken any defense. He only says that मैं बस कुछ देता था इनको और इन्होंने ये सिक्योरिटी अमाउंट रख लिया, लेकिन इसके लिए कोई एविडेंस एड्यूस नहीं किया, ना कोई विटनेस प्रोड्यूस किया है, बस ये एक टोकन डिफेंस है। मैलॉर्ड्स की कोर्ट के सामने आके बस कह दिया कि मेरा ऐसा डिफेंस है, हैंडराइटिंग एक्सपर्ट को एग्जामिन करा के ये बोल दिया कि साइन डिफरेंट है। मैलॉर्ड्स, स्टैट्यूटरी प्रिजम्पशन लाइज इन माय फेवर, व्हेरेइन मैलॉर्ड्स आई हैव सेंट द नोटिस इन द स्टैट्यूटरी टाइम, ही हैज गिवन द चेक, एंड मैलॉर्ड्स अनदर फाइंडिंग इज दैट आप जो जो एक्यूज्ड है उसने 17 चेक दिए, सो मैलॉर्ड्स इट डज नॉट क्वैशेस द presumption that is in my favor. 17 चेक दिए तो हो सकता है मुझे पैसे लेने थे, that was lying or due from a very long time, and subsequently upon repeated asking he gave me 17 checks for amounting of rupees 5,000, 10,000, 15,000, and subsequently all the checks were distributed or presented before the bank by me and all were bounced. Also, my lords, in the light of, my lords, the judgment of the Honorable Supreme Court in wherein the accused does not lead any defense to raise the presumption that he has not given the check, my lords. On this slide, my lords, I am submitting judgment. AR Online 2019 1285, wherein, my lords, failure of the accused to rebut presumption by leading evidence. If he fails to do so, my lords, then it will be deemed that statutory presumption has arisen, and merely by producing a handwriting expert, he will not be evading his liability, my lords.
ठीक.
On the same letter, I am supporting 4 judgments. Very much, the Honorable Supreme Court says that all basic ingredients of Section 138 are apparent on the face of the record. Therefore, it is required to be presumed that checks in question were drawn for consideration and complainant received it in the discharge of his existing debt. And also, my lords, it is well settled, my lords, also mentioned in one of the judgments, my lords, I have quoted that even if the complainant fills the check, it does not absolve the accused of his liability, my lords. It is immaterial who fills the check. If he admits his signature and admits that I have given the said checks, then he has to put his defense, my lords.
ठीक है, वो तो आए नहीं, हम रिजर्व कर लेते हैं जजमेंट के
My
लिए.
lords,
करना चाहेंगे तो आगे बहस कर देंगे. रिजर्व फॉर
my lords, great.